The paper that we've circulated is the fifth, maybe, in a series of papers we've written together on the Second Amendment over the past few years. This one is The Ambitions of History and Tradition in and Beyond the Second Amendment. It is forthcoming in the Penn Law Review, just a few issues removed from Joelle's great and thought-provoking paper, Bruin Was Right. So it's excellent to be in actual dialogue in person and not just in print. To try to make best use of our time, I'm going to start by just giving a very dense overview of what we're trying to achieve in the paper, and then we'll go back and forth a little bit trying to unpack a few of the claims. But just to give again a sort of like compacted version of the paper, what we're trying to do here is show how the history and tradition test adopted in Bruin emerged from a conservative critique of the tiers of scrutiny. And that critique is really a cluster of claims involving, for example, the claim that the tiers of scrutiny lack originalist foundation, that they suffer from levels of generality problems, that they involve balancing, and that those things together license a kind of judicial discretion which blends or maybe brings together law and politics. As we see it, this critique has sort of hit its apex thus far, at least in the Second Amendment context. So in the paper, we do a close reading of the Supreme Court's Second Amendment cases and some Court of Appeals cases, and we conclude that the history and tradition method, at least as it's used to sort of construct and implement the Second Amendment, ends up suffering from those same problems, that there are levels of generality problems, that it eventually involves some kind of means-end scrutiny, and that it licenses judicial discretion. But we think what's worse, it does so in ways that are far less transparent than the tiers of scrutiny which it has been adopted to replace, and we think that that itself creates a sort of a new form of democracy problem. So that's a very, very quick overview. I'll turn it over to Reva to say a little bit about some specific claims.
So we start out, the paper doesn't start out, but I'll start out our claims in short form to say that we're going to take us back to the origins of the critique, then Judge Kavanaugh's dissent in Heller 2 and a Cornell 2017 speech, at which time we could say in that era that Justice Thomas and Alito were complaining that judges were treating the Second Amendment as a second-class right. And Judge Kavanaugh intervened really in a brilliant stroke, translating out of the outcome-based objections to the Second Amendment decisions into a new language, saying that there was a problem of judicial discretion in the means-end test that judges were then using. And then going farther, Joelle and John Ohlendorf explained in their 2019 article against constitutional tiers of scrutiny, there's a problem because the means-ends test lacked grounding in original understanding and had levels of generality problems. Kavanaugh later quotes their article in his Rahimi concurrence, asserting that the tiers of scrutiny have no basis in the text or original meaning of the Constitution. That's a quote from his Rahimi concurrence, and contending that scrutiny tests amount to balancing and therefore judicial policymaking. So this is the origins of the critique. And the paper that you have, we do a close reading of the Second Amendment cases in Heller, Bruin, and Rahimi in order to demonstrate that those decisions don't adhere to the original understanding in any methodologically replicable sense and are themselves pervaded by levels of generality problems that are in fact dividing the conservative justices who are unwilling to commit to principles that would tie interpretation of the rights and regulation at something like commensurate levels of generality or would bind the court in its decisions over time. And the reason we pay attention in close detail in the ways we do have to do with the levels of self-consciousness of the justices of this very problem.
So one way to illustrate this that we try to do in the paper is by teasing out what we call two Bruins, that is sort of two different approaches to the historical analogical method, both of which I think you can find within the Bruin majority opinion. So one of those approaches recognizes that both rights claims and forms of regulation change over time, that, for example, as technological and social changes impact gun power, gun violence, that regulatory authority sort of floats with it. We call that Bruin 1. Bruin 2 looks a little different, and it licenses expansion of rights, but seems to hold the regulatory authority to a much tighter standard. And this happens, sort of as Reva was saying, through a kind of a form of a level of generality move, which is to define the right quite broadly, or the elements of the right, people, arms, keep, bear, et cetera, but then to demand much closer connections when it comes to the regulatory history, the regulatory tradition. 2 years after Bruin, in Rahimi, the court seems to reject this sort of asymmetric approach and restates Bruin's test in terms of a search for the principles underlying our historical tradition of gun regulation. Again, reiterating, this is not about a search for historical twins. So that seems to endorse sort of Bruin version 1. But there are a number of concurring opinions in Rahimi which make it a little tough to know how much the majority of the court is committed to that sort of symmetric updating as opposed to maybe the sort of Bruin 2 version, which puts a thumb on the scale in favor of the right as opposed to regulation. Some of the justices explicitly expressed their discomfort with the turn to principles. So I think we await sort of further guidance on that. I think one of the things that we find so remarkable, and then I'll turn it back to Reva, is, as she suggested a moment ago, how much of this stuff actually has kind of come into the open between the justices, including in the majority in Rahimi, but spilling over into other contexts as well, including the First Amendment cases like Vidal. We have the justices actually really engaging with one another on this exact methodological question.
So now I'm going to push us more in the wrap-up mode in virtue of the time constraints here. So in replacing Minzen's review with a history-based approach, the court claimed that it was constraining judicial discretion, yet our paper shows in some detail that the history and tradition cases do the reverse and more. They create doctrinal discretion that affords the conservative majority new opportunities, one, to advance its values, in two, considerably less transparent ways. History and tradition review allows the judges to reason about gun rights and regulation at disparate levels of generality, extending rights protection to modern guns while requiring gun laws to resemble ancient analogs, a strategy that the majority rejects in Rahimi, but that many of the justices push back against in their concurring opinions. We report debate over all this, as I was suggesting, enough to show that there's this level of self-consciousness on the court, and that the conservative justices are talking about the constraints of history precisely as they are crafting doctrine to preserve judicial discretion. So that's why we're calling it double talk. The language of constraint is being used at the very moment at which they're refusing to commit to principles. In Scalia's era, it was easy for conservatives in a movement that remained decades from controlling the court to attack judicial discretion as politics, not law, and to promise a method that could deliver on law rather than politics. But the conservative legal movement now controls the court. As originalists, including Will here and Sharif, who's not, are beginning to point out, you cannot have judging without judgment. Because conservative justices are uncomfortable in taking responsibility for the judgments they're in fact making, they express them in arcane sites that even an educated public cannot understand. In its refusal to take responsibility for judging, history and tradition is different than means-ends review. And this leads us to our normative bottom line, that history and tradition's double talk inflicts unique democratic harms. It encourages judges to ignore the public. It sets out criteria that encourages judges to ignore the public's reasons for enacting gun laws and provides resources for judges to conceal value judgments in historical citations and level of generality choices, thus preventing the very kinds of democratic oversight that led to the development of history and tradition itself, or the court that developed history and tradition itself. So last sentence here in line the last half minute, the Second Amendment cases suggest that the court's drive to extend history and tradition approaches to other areas of constitutional law can be expected to reproduce the problems we see in the Second Amendment context while insulating the court's control of the Constitution from the public governed by it.
Well, I thank Mike Rappaport and Mike Ramsey for inviting me to serve as the commentator for Joseph and Reva's article. I last had a chance to talk about these Second Amendment issues with Joseph many years ago, and so it's a pleasure to get to do this again. And it's great to be asked to comment on scholarship of two scholars whose work I've long admired and from which I've learned a great deal. And this article is no exception. It's a sophisticated exploration of perhaps the defining challenge facing the court's historical tradition methodology as exemplified in Bruen, the level of generality problem. And indeed, while I have some disagreements with parts 1 and 2 of the paper, and I'll note one of them in my remarks, by and large, I agreed with a lot of what was in those two parts of the paper because they were pointing out the level of generality problem and giving a lot of detailed examples of it. So most of my comments are about part 3 of the article. The first comment is doctrinal in nature, how best to interpret Heller, Bruen, and Rahimi. So Joseph, Reva, and I agree that Bruen has 2 steps. Bruen characterizes the first step as requiring the rights claimant to show that their conduct fits within the plain text of the Second Amendment. Second step requires the government to justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearms regulation. We also agree that insofar as step 1 focuses on the original semantic meaning of the text with only enough historical context to disambiguate among different semantic meanings, and step 2 focuses on the broader historical context like contemporaneous arms regulation, that's going to introduce an asymmetry. The level of generality at step 1 will be higher than the level of generality at step 2, since the text is framed in broad and unqualified terms, while historical tradition is much richer and more detailed. Joseph and Reva object to that asymmetry for historical and normative reasons. Where we disagree is on whether Heller, Bruen, and Rahimi are best read to require that asymmetrical result. Because I believe that step 1 is about original semantic meaning and step 2 is about historical tradition, I think that asymmetry is required by those cases. Joseph and Reva, by contrast, see the 2 steps as not involving meaningfully different types of evidence. They seem to think that step 1 is about the scope of the right, step 2 is about the scope of regulatory authority, but the kinds of evidence considered at both steps is generally the same. That's how I take them, what I take them to be saying. Whereas in my view, step 1 and step 2 are both about the scope of the right, the contours of the right. They're just about different kinds of evidence. Step 1 is more about text, step 2 is more about historical tradition. I provide reasons for my interpretation in Bruen Was Right, my article, and I won't rehash those arguments here. I'll just note one argument by way of example. Bruen devotes only 6 paragraphs spread over 2 pages to its step 1 analysis. In analyzing the key question in that case, whether carrying arms outside the home fits within the plain meaning of bear arms, the court focuses almost exclusively on exclusively actually, on the original semantic meaning laid out in Heller and whether confining carriage to the home would effectively read the word bear out of the Second Amendment. In those 5 paragraphs, it spends no time on historical analysis at all. By contrast, Bruen devotes dozens of pages to detailed historical analysis at step 2. I think that's hard to reconcile with Reva and Joseph's understanding of Bruen. I think it'd be useful for the article to respond to those points in a little more detail than the piece currently does, especially on pages 63 and 64. The second area for further reflection is originalist bona fides of Bruen. A key premise of Joseph and Reva's critique of Bruen is that it lacks an originalist foundation. Their article proceeds mostly as an internal critique, accepting Bruen's originalist aspirations and using that as a baseline against which to measure Bruen's success in achieving those aspirations. And the lack of an originalist grounding for Bruen, in their view, is a key reason why they think Bruen has no democratic legitimacy, since Bruen can't even claim, in their view, to be representing the views of the people in the past. Now, I think there are 3 problems with this critique. The first is that it sometimes conflates Bruen's text and history methodology with specific applications of that methodology. So, for example, on page 54, referring back to their discussion in section 1A, they argue that Heller did not rely on historical materials in asserting that the Second Amendment covers modern weaponry. I'll note in passing that immediately preceding Justice Scalia's discussion of modern weaponry in Heller, he laid out the original semantic meaning of arms, which was not confined to weapons that had in existence at the time. So I'm skeptical of their reading of Heller on this point, but leave that aside for now. Even if that passage of Heller was ahistorical, that would simply mean that Heller misapplied originalism in his discussion of modern arms. It would not undermine the originalist legitimacy of conducting a historical analysis to determine which arms should be protected, which is what both Heller and Bruen's methodology requires. In other words, one can see Bruen's methodology as originalist while arguing that some results that the court has reached in applying that methodology are not good originalism. By conflating methodology with application at various points, I think Joseph and Reva's critique loses some of its force. This is also why their criticism of my article on page 64 of theirs for not engaging with the accuracy of Bruin's historical claims is misguided in my view. One can defend the theoretical and conceptual soundness of an originalist methodology without defending the applications of that methodology to specific historical questions, and that's all I was trying to do in that paper. The second problem with their critique is that while they cite some of the scholarship that has defended Bruin's methodology, they generally do not engage with the theoretical arguments offered by those pieces for why it is in fact an originalist methodology. They point out that originalists have disagreed among themselves about whether Bruin is originalist, and note that that's, in their view, a problem. It may or may not be a problem that originalists disagree so much about this methodology, but it's a fallacy, I think, to move from the fact of disagreement to the conclusion that one or more particular arguments within that disagreement must be wrong. The third problem with their critique of Bruin's originalist bona fides is that it does not consider historical accounts that would, in fact, support Bruin's methodology. Now, Joseph and Reva assert that Bruin's methodology and my defense of it have no warrant in history and contrary to the founding era conception of rights, citing Judd Campbell's work. Now, while I take a backseat to no one in my admiration for Judd and his scholarship, I've recently argued that neither his work nor the work of Jonathan Gannap or Jamal Green undermines the historical accuracy of Bruin's conception of rights or its burden-shifting regime. I'll just note here that Ryan Snyder and Philip Hamburger have pieces that are going to be submitted in the February cycle that make additional arguments on this, along these lines. There is ample historical evidence that the First Congress paid close attention to the language of the Bill of Rights and chose words that would best reflect the understanding of those rights at the time. In Samuel Livermore's words, they chose texts that would reflect, quote, the usages of law and practice among us, unquote, seeking to ensure that the text would be, quote, declaratory of the law as it now stood, unquote. It therefore makes sense to treat violation of the text as prima facie evidence of violation of the underlying right that the text was intended, albeit imperfectly, to capture. That, in brief, is what justifies Bruin's shift of the burden to the government after the rights claimant has demonstrated a violation of the text at step one. But precisely because the text could not fully capture such a complex and rich understanding of rights, it also makes sense to proceed to conduct a historical analysis to fully recover the meaning of the right, and that's the purpose of step two. And once again, there's ample historical evidence that those in the First Congress understood these rights, in the words of James Madison, as, quote, accepting out of the grant of power, unquote, whatever was understood to be encompassed within those rights. This, again, is fully consistent with Bruin's methodology and its conception of rights, especially at step two, which looks to the law as it then stood, to quote Livermore again, in recovering the content of the right. This evidence is all laid out in my article, Bruin and the Founding Era Conception of Rights, forthcoming in the Notre Dame Law Review. And to be clear, I don't expect Joseph and Reva to, on a rolling basis, account for every Second Amendment piece that's just coming out. So I'm certainly not faulting them for not addressing this evidence at this point in this paper. I'm just pointing out the article because I think it would strengthen their piece if they addressed that evidence or at least qualified their critique along these lines. The final area for further reflection is conceptual. Throughout their article, and especially on pages 56 through 59, Joseph and Reva seem to assume there's no historically constrained principled approach to the level of generality problem. They appear to believe that ultimately the level of generality issue is judge-generated and normative all the way down, and that Bruin hides the ball as a result by not just confessing that it's doing normative reasoning all the way down. If they don't think that, then I think they should clarify that because that is the impression their paper gives. In any event, while Joseph and Reva are correct that deciding on the level of generality cannot avoid normative reasoning, that normative reasoning can be historically constrained, and it's notable that they do not address proposals for how to resolve the level of generality problem under Bruin in a principled fashion. Mark DiGirolamo has suggested such an approach. I have at length, and Bruin was right, and while I wouldn't expect, again, Joseph and Reva to necessarily be aware of Sharif Girgis's current draft article, he has a brilliant piece offering another proposal for addressing the level of generality problem in a more principled fashion. I don't want to rehearse all these proposals here, but again, I think the draft would be strengthened by either addressing those proposals or qualifying the critique on this front. Of course, it's possible that the piece is too far along in the editing process or that it would add too many words to take account of all the things I've just said. It'd be perfectly reasonable for Joseph and Reva to address some of these points in separate pieces rather than here. but at the very least, Broad claims that there's no originalist basis for Bruin's methodology, or that Bruin has a level of generality problem cannot be made without addressing these and other counterarguments that Joseph and Reva leave untouched.
Fantastic, and thank you, as always, Joelle, and thank you for mentioning your Notre Dame piece. I commend it to everybody. One of the things that's wonderful about that piece is it does what a lot of defenders of Bruin don't, which is actually engage with the history that Bruin seems to be pointing to. Lots of people defend Bruin without actually doing the historical work, and Joelle's most recent piece does do that. In interest of just how limited our time is here and accepting Joelle's invitation that we need to write more and answer this kind of stuff in print, let me just focus on one thing which I don't think works to solve the level of generality problem in Bruin, which is the push to focus on the plain text, which Joel mentioned in his remarks and is defended at length in his paper. And again, just in case this goes by quickly, the post-Bruin world has sort of shaped into like a two-part test. Step one, challenger has to show that they fall within the plain text of the amendment. If so, burden flips to the government to show a regulatory tradition sufficient to defend the regulation. And I think Joelle's right that it makes sense for the burden to shift if that's how the two steps going to work. The reason I don't think that the plain text, the way that Joel's described it, I think can solve this problem is I don't think we can separate the text and the history that cleanly. I don't actually think that's even what Bruin does. Bruin refers to the text informed by history. Heller does the same. I think there's going to be history operating at the first step, whether you call it the plain text or not. I'm also just skeptical that that's what Heller really did. The question in Heller wasn't what is the scope of arms or people or keep or bear. The question was whether the Second Amendment protects an individual right to keep and bear arms for private purposes like self-defense. So Justice Scalia does cite dictionaries sort of suggesting that those terms weren't limited to the organized militia, but I think he would be surprised to think that his citation to 3 dictionaries gives us, actually 2 on this question, gives us the definition of arms. And if anything, I think if we plug it into that 2-step test that Joel's described, we get some bizarre results. And as Joel's pointed out, actually in his brief at Wolford, in his Notre Dame piece, it would be weird if the 2-step test had nothing at the first step, such that all gun laws were presumptively unconstitutional. But if we take Heller as having defined the plain text, that's the result. Because Heller, I mean, if we look at the 3 main words we might look at, people, arms, keep and bear, Heller's all over the place in defining people, but it does say law-abiding citizens, it's all members of the political community, hugely broad definition. When it comes to arms, it cites a dictionary which defines arms as all weapons of offense or defense, or anything that a person takes in hand in wrath to strike at another, right? And then when it comes to keep and bear, it says those just mean to have and to carry. You put all those things together, it's almost impossible for me to imagine any weapons law that does not satisfy this plain text a supposed threshold. My 10-year-old is a law-abiding citizen. If he were to take a grenade, which is a weapon of offense or defense, into his school, that is carry, he has fallen within the plain text of the Second Amendment, and any law that prohibits him from doing that is now presumptively unconstitutional. That's no threshold at all. So I think we need to put more, if we're going to have this plain text versus history division, I think a lot more needs to go into the plain text side.
I don't know how we're counting time here. I will just say that we can't solve this for all cases in the way that the cases are now trying to do and call it originalism. What's happening is, however we evaluate the quality of original public meaning originalism in the Heller decision standing by itself, it's getting carried forward in the subsequent cases doctrinally. It's kind of grandfathered in. And that seems to me inadequate to take account of the particular facts involved in the particular subsequent applications of Heller in those cases, if originalism requires an inquiry into the original public meaning of a text, meaning one needs to understand in context the meaning of the text, and that never happens in the subsequent cases. That's where history would come into the text part of the first step, and it's not coming in. It just, there's some invocation of plain text and doctrinal stare decisis, see Heller. And so something's not happening at step 1. There's just a burden shift to the government, and then it's getting hit with a very heavy burden of, if not matching, then showing a very close likeness to the regulations of the past. So they're hugely disparate burdens that are being imposed on or showings on the right side and the regulation side. I'm just trying to be brief here. And that is creating an immense democracy problem. It's both deregulatory and also it's obfuscating the extent to which the test itself is importing a strong pro-gun perspective, in that it's creating a framework which is protective of the gun right in the way that your paper says. But the one thing we know is that the founders want to protect gun rights against evisceration, but we don't know what counts as evisceration within the meaning of the test. So I'm on a 3-minute version. I can't say more, but there's a problem. I don't know what the standard, being an outsider to this amazing gathering, I'm not sure what the norms are, so I've been trying to keep my remarks brief. But I will say, to conclude this, that it's very confusing the extent to which there's actual methodological originalism going on in these cases, as distinct from doctrinal work, referring back to prior cases, that's being characterized as originalist. And to me, it seems like the latter is actually happening more frequently than the former, which is creating a problem.
Reva and Joseph, another trenchant collaboration. You argue from jump that history and tradition review finds no plausible anchor in originalism or original public meaning. My question is whether you see that tension as fundamentally irresolvable, or whether there exists some version of history and tradition that could be reconciled with a founding era or a fidelity to founding era meaning.
Rahimi isn't. It's one of the few actual original Bill of Rights cases. But Rahimi, my complaint is that they're not talking about the extent of federal power. Why does the federal government have any power to disarm these folks? But if we were to make it a real 14th Amendment case, there would be resources in the 14th Amendment history that would help you figure out how to answer these kinds of questions paradigmatically. Corfield versus Coryell from 1825, which talks about history, the privileges and immunities, which have at all times been enjoyed by the citizens of the several states from the time of their becoming free, independent, sovereign. So you have this, history is the root, but then you also have this question, which is the same question that you get in Bruin, where you talk about rights, where Bushrod Washington talks about the right of the government, that talks about these privileges, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. So wouldn't we be better off asking how that's supposed to work, rather than going back to this anachronistic application of 1791 stuff against the states, which that's just not the right reading of the 14th Amendment.
Thank you for the paper. There's a lot I agree with in it. On page 55, in part 3C1, at the top, you write, some originalists have discussed the originalist pedigree of Bruin's analogical method charitably, and the footnote is to Randy and I, while others have harshly rejected its method as indeterminate. And then you say, there's obviously a problem if originalists cannot agree about these matters. So if you read the sources in the footnote, they are talking about different subjects. Randy and I are saying that history is relevant to the content of the right, step 1, and that the historical analogy test is possibly an implementing rule for carrying that meaning into execution. We say nothing about whether or not the historical analogy test actually works, whether or not it's determinate. That's what the sources you cite in the next footnote are talking about. And it seems to me that it's not obviously a problem. that originalists can disagree about things, even though in this particular case there isn't actually any disagreement. It's a good thing. It's something we should welcome, that scholars are working out problems raised by the Supreme Court for originalist theory. It would be very, very strange indeed if all the originalists agreed on something like the historical analogy test, especially given theoretical divergence among originalists, right? The way that we make progress, sort of in the academy at least, on these issues, and it may or may not carry over to the courts, is by airing these disagreements, working the arguments out. And I would just point out, this is a tu quoque, right, that if we were to apply this, it's obviously a problem if constitutional theorists disagree at the level of theory and or application of theory. Living constitutionalism is in no better shape than an originalism in that regard. I try to keep track of the forms of living constitutionalism. My list is up to 27 now. And not to mention the several different forms of congressional supremacy theory. So, and that's a healthy thing too, right? But there just isn't a problem here that originalists disagree. And what you cite as disagreement is actually people talking about different topics.
Okay, so a few things. First, I know we don't have to respond to everyone, but I'll say a few quick things. Dove, I think because I want to say there are many flavors of history and tradition. I would count Griswold as, in fact, drawing on history and tradition every bit as much as Dobbs is. Dobbs is just at a lower level, not just, it is at a lower level of generality and looking to the past to fix things in a way that Justice Harlan, for example, is not. So I want to be very clear that there are many, many, many ways one could, in our tradition, do history and tradition, and that, in fact, the court is now, even now, doing history and tradition in multiple ways, so that there isn't one. And as Larry's just been telling us, there are many ways of doing originalism in this room, represented quite impressively, so I can't answer your question about their compatibility with one another, okay? That's number one. Number two, Chris, just your comments about the 14th Amendment tripped off for me the fact that right now I'm reading Josh Craddock writing on the personhood of preborn, as he puts it, life under the 14th Amendment, and he's looking to Justice Scalia's opinion in Heller for how to read the 14th Amendment and moving at a very high level of generality, using the very forms of high-level generality reasoning in the gun cases as a model for how to read the 14th Amendment's use of person. So it's not in the direction of privileges and immunities as you're talking right now, but of course where's Steve? People in the room who would take that as the better way into the 14th Amendment. Of course, there's different directions in which one can move looking for history, but if a tradition is at issue, there's no reason we're going to have to privilege one clause over another or pre-ratification history over post-ratification history. That's a question to be faced. And three, Larry. So here the question is, there is an asymmetry here, but not the asymmetry we're talking about, or one of the asymmetries we're talking about. And it really goes to the following question, whether, so I don't label myself a living constitutionalist, but as you might know, I don't call myself an originalist either. And I, however, do think that people engaged in constitutional interpretation make judgments and make contestable judgments. But I do know that, for example, if I read Rahimi and I look at how it is that Justice Gorsuch or Justice Kavanaugh are talking about originalism, they talk Justice Scalia's language about objectivity of judgment and impersonality of judgment. And because there's at least that tradition in the scholarship of originalism, that pluralism in originalism is kind of a problem if originalism is going to claim for itself that impersonality and impersonality of decision-making, objectivity in decision-making or interpretation, which it often does, namely the ability to render kinds of judgments that can be relied on to separate decisions from the interpreter, and that judges can rely on to make decisions in interpreting the court that will be independent of the judge's own preferences or values. That's the problem, and that's not commensurable between what you're calling living constitutionalism, responsive judging, and on the other hand, originalism. Originalism does have a burden if it's at least the form of originalism that's going to generate that kind of claim for itself, but perhaps that's only a species of originalism.
So I'll just add something very quickly and then turn it over to Joelle. And it also a thought inspired by your comment, Chris. The sort of invocation of like regulating for the general good of the whole, I think is like really, really important and useful to illustrate, again, the hydraulics of the sort of like step one, step two, like you could wave everything in at a very, very, broad, easy to satisfy threshold step one, if the step two allows the government, society to regulate for the general good of the whole. The thing that I worry about in this sort of post-Bruin world with the asymmetry is that it's incredibly easy to satisfy step one. Again, 10-year-old grenade in a school satisfies Bruin step one as a matter of plain text. But then the burden shifts to the government in a very hard way to satisfy with these historical regulations on a PI schedule. It's very tough. We're seeing like, what I see is like, just kind of like not results that to me could reflect any potential useful historical meaning. That's not the only way to do it, though. I mean, we're talking about tiers versus history and tradition. There's all kinds of different ways to evaluate the constitutionality of gun laws, and I've been banging this drum, but nobody listens. That before Heller, states had, under their state constitutions, individual rights provisions which were litigated and subject to an almost unanimous reasonableness test. That is, you could invoke your individual right to keep and bear arms for self-defense under a state constitution, and every state I'm aware of tested those laws according to reasonableness. That would be another test. Another one would be, and this I'm taking from another great article published in the Notre Dame Law Review, this one by Will and Rob Leiter, you could have a test that would ask, quote, whether the conduct fell within the scope of the right, and then, if so, quote, whether the legislature reasonably regulated the right using its police power. And I maybe sort of call ahead to Eric's paper for tomorrow. That's another test, which again allows more flexibility on the second side and makes the sort of asymmetry, I think, a little bit less problematic. That also, by the way, describes the two-part framework that Bruin rejected. Like, that was the state of play in the courts for 15 years after Heller, and that Bruin said you can't do anymore. And I think that's where the sort of hydraulics become, at least to me, quite problematic. Turn it over to Joelle.
Okay. Can I just say one thing? I'm sitting here feeling remorse at the way I responded to Larry. I want to say that, to be very clear, I totally admire this community of interpretation. I totally admire people going on and disagreeing with each other over time. It's not for any my lacking valuing that practice. I'm simply saying that there are those amongst your midst who claim for this particular species of interpretation a virtue over what you're calling living constitutionalism that might hold this practice of interpretation to a different standard. You're suggesting even standard. I'm saying that would be great. That's where I'll leave it.
Just very quickly, Chris, I'm very sympathetic to your way of thinking about how the court should be approaching these issues, that it should be through the 14th Amendment Privileges or Immunities Clause. The reason why we're not talking about it very much is because Joseph and Reva's paper is theoretical and methodological, and my responses were in the same vein, so we just weren't getting into a lot of these questions about the difference between 1791 versus 1868. I do want to make just one quick, if I may, Tom, response to the points that Joseph was making about this asymmetry. I'll just make two quick points. One is that I kind of reflexively like chafe at the idea that the mere fact that there's an asymmetry that could lead to a broad presumptive protection and then on the back end a burden on the government, that by itself, the description of that makes it wrong or makes it objectionable. It could very well be that historically the right was quite broad and was intended to leave a broad space for the right to keep and bear arms. And if that's true historically, which is what I contend in the Notre Dame piece, then there's just nothing wrong as an originalist matter with this two-step approach that creates a broad presumptive protection that is then pared back by a historical inquiry at step two. And we shouldn't reject that just because we don't like potentially, that there's such an asymmetry, at least from an originalist perspective. And the second point I would make is this is not that unusual, actually, in constitutional law. So in the free speech context, for example, it is very easy, when you're talking about verbal or written communication. Obviously, expressive conduct is much more complicated in this respect. But if you're talking about written or verbal communication, you're in the door pretty easily on rights protection. And in almost every subgroup of free speech doctrine, once you're in the door, the burden is on the government at intermediate or strict scrutiny to carry forward the regulation. So it's not as if what Bruin is doing at steps 1 and 2 is radically different than what the living constitutionalist tiers of scrutiny approach has done in the free speech domain, and I don't understand why that's only objectionable in the Second Amendment context.
Hi, thanks very much. First, I just have a question for the panel. Since you all have done so much work looking at this formula, history and tradition, is there any thoughts just on whether those words are redundant or they have some kind of what's the relationship between history on the one hand and tradition on the other? And the second point I wanted to just make, piggybacking on what Joel said, is if the text suggests that there are rights that are prior that should not be abridged or should not be infringed by the state, and if the theory was that we are a free people first and a governmental association second, that would suggest there's good reason why free speech and right to bear arms, once they're on the table, because they're prior to democratic organization, there would be an asymmetry in the way we address those.
I also found a lot of the critiques very persuasive. And I have to say, I came away thinking, boy, if Heller and Bruin and Rahimi were like a tenure file, it would not be very good. But I guess then that made me wonder if there's a category error here, because this is not a tenure file, right? It's the first few decisions in an attempt to establish a doctrine. And I wonder if actually we're just expecting a level of intellectual and theoretical coherence that it's impossible to really have. The justices have made clear they have different methodological approaches. Not all the justices who joined these opinions even claim to be originalists. And the ones who do claim to be originalists have very different theories of originalism, some that lean much more on constraint, like Justice Kavanaugh, some that lean much more on positivism, like Justice Barrett. And it seems obvious that what the doctrine really is a sort of incompletely theorized agreement. It's an attempt to articulate some criteria for decision that they will use to generate doctrine over time that they can all be okay with for different reasons. And so it doesn't hold together very well. And indeed, like these critiques, I think, are all very helpful ways to think about what the decisions this term will have to say. And maybe if there are 10 more decisions, we can finally start to ask whether or not they are being inconsistent or whether they've somehow coalesced on a level of generality that was not commanded by the methodology, but they've kind of found it anyway. But it seems like the ultimate topic here is not really a critique of originalism or a history and tradition test, but it's more something like originalism by committee.
Really enjoyed this paper. And I wanted to suggest that perhaps this isn't a level of generality problem, but that it's a problem. You've bumped up in your paper, and I took your critiques seriously and agreed with most of them, that you're bumping up against a sub silento disagreement that originalists don't know about or may perceive in different ways between the theory of originalism and the practice. And the theory is based off of generally fixity and constraint, and the practice is based off of how originalism has been taught, frankly, at Yale and Harvard until recently, of text history and tradition, or text history and structure, based off of a particular teacher or professor who has taught at both places. And now I think we might see a shift in the practice of originalism. Those who practice it think that that is originalism, whereas those in the academy know that it's not. And we don't realize that we're talking about completely different things. And this was actually, I have Randy to credit. I wrote a paper in one tradition. He said this partakes of a particular tradition, and it's not originalism. So I think we're talking about different things here, and I wonder if that's what you're bumping up against rather than a level of generality problem.
I'll just say a few things very quickly, and actually this will be maybe responsive, David, to your second question, and hopefully also responsive to Joelle, because I want to be clear, I don't have any problem, I don't think we do, with a world in which when a fundamental right is on the table, the burden flips to the government. I think the tricky thing for us, and this is my objection to the plain text test, is it doesn't give us much guidance about when it's on the table. Like coverage, question of coverage, you'd call it in the First Amendment context. Like something has to happen first in order to know that the right is on the table. And again, I mean, I realize that like the sort of, you know, kid carrying a grenade into a school thing sounds ridiculous, but that's what I mean, is like a test that can't sort that out is missing something. And maybe eventually, this goes to transition to sort of Will's point, we'll get there. I think that's exactly right. I think it's fair. I mean, in a way, I say this often, it feels to me like the Second Amendment is today where the First Amendment was about a century ago, which is you're just still starting to get on the table what the basic theories are. Like, is this about self-defense? Is it about the prevention of tyranny? Is it about something else? Like, what are the tools gonna be? And when the doctrine matures, I hope that we'll get more tools on the table. I say this as the author of a Second Amendment casebook, that it's not just Bruen answers everything. Like, that can't be right. And had the court taken more Second Amendment cases in the 15 years after Heller, maybe we'd have a little bit more guidance on here's the kinds of, for example, people convicted of disqualifying felonies who can be disarmed and those who can't. I absolutely think that's where we're going to get. I think the thing that troubles me about Bruen is how quickly it hit the reset button on that development project. I mean, the day after Bruen, if you went on Westlaw, every Second Amendment case was red flagged. I mean, that is a huge reset on a developing doctrine. Again, a rejection of a two-part framework which had been unanimously adopted throughout the federal courts of appeal, except for the Federal Circuit, which doesn't get Second Amendment cases, and the Eighth Circuit, which didn't reject it but didn't fully adopt it. That's a remarkable revolution. And so I think maybe it is true we're in the rubble of it now. Rahimi seems to me like a step forward. Maybe Wolford and Hamani will continue down that path.
Reva, did you want to say anything?
Just on that point on the red flag, I remember reading Bruen, and I just remember my jaw dangling when I was reading it because I realized how many cases were going to get red flagged by what I was reading, and I was thinking, this law? You know, like, I couldn't believe the breadth of it and what was going to follow from it. So in that respect, it was intentional, and what's followed, I guess, was within the intention of it's what Justice Thomas wanted for his birthday. I don't know. Anyway, so what I want to say about exactly is the coverage problem. And there's tons of speech that is not within the coverage of the First Amendment. And it is taking a while trying to figure out what is or isn't, and that's getting reworked all the time. But the test now is primitive for that. So yes, no tenure, probably not pass the exam. Worse. Anyway, I mean, it's just not plausibly law even, really, but it is law. Sorry, I shouldn't go on about this, so I'll stop because we should get other
I'll just quickly say, so one on the, like Joseph and Reva, when I first read Bruen, I also was astonished by how delighted I was that it that it took all of those made-up tests from the Court of Appeals and threw them in the trash where they belonged. And I don't think that the fact that we're so early in this project I agree, I should say, actually, that because we're so early in this project, it seems like this is an area where the three of us are agreeing, means that we shouldn't draw too hasty a conclusion at this point about the fate of the methodology. This is something that some scholars who've been critical of Bruen have done that I think is far too premature by just saying, well, look, there are all these things that are uncertain about the way the methodology applies. That means the methodology is fatally flawed. Well, of course that's not what it means. It just means that all we've had is a few years from Bruen, this watershed decision, which wasn't going to work out every single one of these things in one opinion. And yeah, you would expect a lot of disagreement about those big, complex theoretical questions until they're fully worked out. None of that is evidence that the methodology itself is doomed to failure. And I'll just very quickly say on the free speech point that I was making, the current free speech doctrine is extremely broad at the coverage stage, at the triggering right stage, as Professor Fallon would have said, right? That you get in the door for a free speech case with an extremely minimal burden, again, with expressive conduct being the different category there. But for verbal or written communication, you're in the door very easily. And yeah, there are all these categories that are not deemed to be part of the freedom of speech. But that's when you get to the categorical exclusions after we find out that the free speech clause is even on the table, right? And the government is the one that has to show that there's a categorical exclusion that applies, right? Under Stevens and Brown versus Entertainment Merchants. So my point is just to say, is not to say that the current free speech doctrine is right in that regard. I'm simply saying that this is nothing new to our law right now to say that getting in the door for coverage and triggering the right is relatively easy.
I'm wondering if you would agree with this as a characterization for why the asymmetry issue that you point out is somewhat problematic, which is that Bruin's two steps, and so the high generality for rights, low generality for regulations, comes from the fact that it equivocates on the method of originalism that it uses. The step one, we have a high level of generality because we have semantic text. We have the word arms to interpret. It tells us the level of generality. Step two, the level of generality is much more contestable / less clear. And the problem with that is that within the test, it's equivocating on what kind of originalism it's using. And that's not to say that one or the other is necessarily better. I think referring to the concept in both cases makes more sense. But that is, I think, a useful way of explaining why this asymmetry is maybe reads as opportunistic, because it is sort of switching what's going on inside the test itself.
So Chris Green had basically my question, so I'll just re-ask it, but in a crazier way, which is not only, is the 14th Amendment the relevant text here, but some of us, by which I mean me and John Harrison on like a good day, I don't know if it's one of his good days, he could let me know, think that incorporation of the Bill of Rights is incorrect, and that an abridgment of the privilege or of a privilege or immunity just means, is this unrelated to the purpose of the right? Is this invidious discrimination? There's no public interest in this regulation. And that actually solves a lot of problems, right? I mean, makes Bruin, I think, an easy case, actually, because whatever the right is, it can't possibly be that there's so much discretion in an official that effectively only rich and powerful people get these licenses. It's like a Yick-Wo kind of case. The 18-year-old gun case actually strikes me as easy because I think Adkins v. Children's Hospital was correct. And once you grant political rights, the highest form of rights, you have to justify discrimination in civil rights. So 18-year-olds can vote. I think that means they can have guns the same way anybody else can. Doesn't mean that there aren't going to be these exercises of judgment that are required. But under this view, also, the tiers of scrutiny start to look pretty good. I mean, Chris and I can fight about this tomorrow with his paper. So I guess the question, which you are totally free to ignore, the virtue of this, rule of three, is that the intractability of, the tiers of scrutiny and the history and tradition and all these problems, doesn't it make any of you want to at least flirt with the possibility that incorporation was wrong, and that this would be just a cleaner analysis if we just focused on the word abridgment and what that means and the discriminatory connotations of that word? I told you it would be crazier version.
So for Joseph and Reva, the history and tradition test reminds me a lot of the Fourth Amendment doctrinal test. And so I'm wondering, would you think it's equally problematic in that context? And if it's not, is it because of the word unreasonable in the Fourth Amendment, or is it because you don't have this gear shift in jurisprudence between Heller and Bruin, right? And then for Joel, sort of a preview of the next panel, the word is people, and generally people mean citizens and non-citizens, at least in the Fourth Amendment context. At least the Supreme Court has said that. And so in terms of the bright line sort of plain text, is that an instance where the preamble actually kind of matters? Because well-regulated militia people, that sort of suggests citizens, although digging into it, I realized that a lot of these militias actually took non-citizens too, because they were hard up for people. So, and then does that mean 18 USC 922G, which says that it's unlawful for somebody who's unlawfully present, is that a violation of Second Amendment rights? Like, how does that all work if you're focusing on plain text to that extent? Because the word people has this aspect to it. It's not citizen.
So Tom's question is a really good one. The person who I know who's written the best stuff on this is Deep Gulasekaram, who's at Colorado, who's written a series of articles trying to address that question on 922G5 or whichever one it is it has to do with. It's a really tricky one, and I think courts have split because it raises the difficulty of figuring out, of all these definitions we've heard of people, law-abiding. Sometimes the court says law-abiding responsible citizens. Does that help justify restrictions on the mentally ill who may not have violated laws but may be responsible? Really hard questions. The Himani case before the court this term involves regular users of habitual users of controlled substances. Again, maybe gives us some guidance. It's kind of adjacent to a lot of those other 922G prohibitors. So I don't have a great answer on that, but I would recommend Deep's work. On the question of infringement, it would be in the Second Amendment context. Daniel Slate of Notre Dame has a fantastic new paper on what infringed means. I'd commend that. And back to your question, Christine, on the equivocation within Bruin, I think you're exactly right. I mean, this is actually one of the reasons why in the paper you see us sort of tease out these two versions of Bruin. Like, I really do think that the resources are there, and you're hearing us criticize Bruin a lot, but I think the resources are within Bruin to have a much, in my view, more coherent and sort of like, and frankly, honest to the historical sources approach. I mean, Bruin says, among other things, that dramatic social and technological changes trigger the need for a more nuanced approach when analyzing a modern gun law, so people might disagree about what counts as a dramatic technological or social change, but to go back to Rahimi, the increased protection of people from intimate partner violence feels like a pretty dramatic social change from 1791. If that means more nuanced approach, if that means a move to principles, that starts to feel to me like it is starting to work itself a little better. Again, Rahimi feels to me like a step in the right direction. And again, just to echo, I wouldn't expect perfect. I mean, this is a really, really, really hard task. It's one of the reasons that I find writing in the area so fun and exciting, and you get to engage on these fundamental questions.
I'll just quickly say that in response to Tom's question, that I think that is a very difficult issue for Bruin to confront. I don't have a settled view on this. I do think it's probably a step one question. That it probably does get resolved at step one about whether aliens or members, especially aliens unlawfully present, are members of the political community as Heller described it, or whether there's some other understanding of the people at step one, as Joseph was saying. So I don't have a settled view on that, but it is something that's dividing the courts at the moment, yeah.
I'll just pop in briefly to say, in response to Christina's question about Bruin, we really did take the time to, as we worked over this paper, identify the so-called two Bruins in the paper to show, I guess, what Will was talking about, the counting to 5 problem. You can see that there's a version of Bruin in there that would do what Rahimi's doing, and you might impute it to Chief Justice Roberts. The views that made him an uncertain member, maybe why they mooted out on the NYSERPA case beforehand, before Bruin, and why he wrote for the majority in Rahimi as he did and didn't concur with himself and Rahimi to undercut that opinion. So there's a view that just one can see there are just different views of what's the right way to settle the case or to decide the case, that there could be an evolutive view of the rights as well as the regulation, et cetera. And also, I want to point out that there are just methodological problems, as I had adverted to at the beginning, in looking to a dictionary to come up with the idea of an arm, and to view that as sufficient. And that super high level of generality to decide whether variant, like an AR-15, whatever, is covered when it could be that you need more background understandings of the kind that show up in Heller Part 3, or that Wilkinson raises in Bianchi or otherwise to understand the meaning of the arm in context when there are other laws that bear on threats to the public, et cetera, that a reasonable understand, that the audiences that are the ratifying generation would have understood by arm in that period. One could do a lot of loops through this material that just disappear when you just treat Heller's decision about handguns as having answered the question for every modern arm, which is what's happening.
Just very quickly on that, I want to say that I think that we should distinguish between a descriptive claim about what's going on in Bruin, about whether we think that there was disagreement among the justices and that you can see some of those disagreements in the methodology. On that, I think there's undoubtedly disagreement among the justices. I think your article does a great job of laying those disagreements out, and so maybe you do see that cropping up in the Bruin opinion. I think that's a different question from whether Bruin's methodology is incoherent or tries to mash together two theories that cannot be reconciled. There, I strongly disagree. Right? I don't think that's right. I think Bruin is coherent and does come out of a coherent understanding of originalism, notwithstanding any disagreements among the justices themselves who produced it.
I agree with a lot of what Joel said about the asymmetry and the need to sort of justify why that's problematic given the current assumptions that we have about rights. Along those lines, this is not for your paper, but just for our general edification, I think the Bill of Rights drafters make a very deliberate choice not to attempt to specify on the powers side. So we know for a fact that their view of the freedom of speech and of the free exercise of religion and of the freedom of the press and of the right to assembly are limited by countervailing governmental powers. And it's very deliberate for them not to specify those limits on powers because they don't want to re-enter into debates about the scope of federal power, and they don't want to suggest that there are problems that might arise that they don't want to grapple with in entering into those debates when the whole effort is just to declare the existence of certain rights. So I think the textual premise of how to analyze powers with respect to Rahimi is just wildly out of line with what the drafters of the Bill of Rights are up to. The second comment is that you might get some mileage out of, I liked your answer, Joseph, about the coverage point. You might get some mileage out of how the court grapples with this problem on the Establishment Clause side as opposed to on the gun rights side. So rather than having a very thin semantic first step followed by a very onerous burden being placed on the government to then do a lot of thick historical reconstruction, on the Establishment Clause side, the court puts a lot of onus on the claimant to come forward with a very thick account of what counts as a law respecting an establishment of religion. And it could be the case that there are ways to justify that differential treatment. I haven't seen the court attempt that justification, and that just sort of bolsters the point you're making about the manipulability of the method.
Thank you, Joseph and Reva, for the paper. I very much enjoyed it and learned a lot from it and found myself agreeing with lots of it too. I thought, though, that there might be one point of focus that might you might benefit from in a kind of revision, which is, Joel makes a very strong argument that there's a reason why there's this difference in kind of level of generality from step 1 to step 2, which is that once you've established that step 1, the government is imposing a burden upon a right, then there's a presumption not of constitutionality but of unconstitutionality. And that's come up a lot more actually in this discussion. And that's a powerful argument, I think, that Joel is trying to make. Obviously, it's also located in Bruin as well, and I didn't see as much engagement with that issue of the presumption of constitutionality versus the presumption of unconstitutionality. Why that might be useful to you, though, is that originalists also have a few thoughts on that question of whether that standard of review, when it comes, whether for the Second Amendment or for any other right, is truly grounded in historical practice. And Chris Green and John McGinnis and others have tried to excavate the historical understanding, originalist understanding of that point, and have actually pushed back on this idea that you would have a presumption of unconstitutionality, whether in the Second Amendment context or in any other context. So in addition to Judd's points, I think that might be worth flagging. Second very quick point, you mentioned Justice Kavanaugh's talk at Catholic University, right, where he was sort of open to this, extending Bruin perhaps in the standard of review. You might also take a look at Justice Barrett's talk also at Catholic University, where I'm, by the way, I teach at Catholic University Law School, but she offered a dissenting opinion on that point. And you do flag Justice Barrett in your paper nicely, but she explicitly, in response to a question, said, I don't favor the extension of this, the hat method to other areas of law. So that might be worth just flagging in your piece.
Hi, thanks so much. I'm wondering if you have thoughts on the level of generality problem, and in particular whether it is a problem, or whether it is merely a recurring problem type, where sometimes we're trying to understand something, and there are different categories that we might be identifying, and some of them are strict subsets of the other. But that doesn't make level of generality per se a problem on its own ground. So, for example, take an interpretive problem, like what does arms mean? You could think of it as meaning, weapons of offense and defense. You could think of it as the way I think Rob Leiter thinks of it, which is weapons that an individual militia member might need to show up with, sort of infantry weapons. You could think of it the way Scalia describes it in Heller as like weapons in common use. These are all different categories. Some of them are just broader and contain the others, but they're all just categories. And it doesn't seem like level of generality is a helpful framework for deciding which one of them might be right, or even for describing the interpretive problem. The interpretive problem is there are many candidate meanings for this term. And generality is sometimes it will be hard to differentiate ones where there are strict subsets or supersets of the other, because things that fit within one also fit within the other. But that's just a frequent occurrence, not a sort of theoretical problem. And I think the same is true with unwritten rules. So, when we're trying to identify the common law on a given topic, sometimes we're going to have generic statements like, about parental rights and so on. And sometimes we're going to have much more precise statements like, Michael H. versus Gerald D. And the idea of looking to the more specific rule is not that we look to the minimal rule that can explain all of the evidence, because, of course, all of the evidence one might use in Michael H. versus Gerald D. occurred before the year 2050, but no one thinks that that's part of the rule. It's more like the problem of saying, I before E, except after C, or when sounding like A, like neighbor or way. Like the more specific rule might better describe the practice, or worse describe the practice, but it seems like that's the problem and the criterion. It's not some separate level of generality issue. And so I'd appreciate your thoughts on it.
First, in response to Steve, the way in which the level of generality question is coming up, and the reason, Joel earlier suggested we had no way of speaking normatively about how it ought to be handled, and we actually, at various points in the paper, do adopt the framework that I understand Rahimi to be advocating, which is that something like at roughly commensurate levels of generality, rather than the strong asymmetry that you're reading as part of the method of Bruin. So we're assuming that we roughly commensurate. We don't say anything more specific than that. What does that mean in this context, Steve? It means that there would be some measure of historical inquiry into meaning in determining the coverage question, which, when you just treat it at the level of a textual account, is this a weapon of defense, or a meaning at that? Then it's at that it means for us is at a very high level of generality, as opposed to asking what were the properties of weapons of defense at the time of ratification. What kind of lethality did they have, or what understandings were there about them relative to other classes of arms, or something like that? One could start asking those questions, which Judge Wilkinson does in Bianchi. So it really has to do with whether there's any kind of, what kind of context is there for understanding meaning, whether it's textual, historical, or otherwise. And that's the question. If one does it at a very high level, then one can also just talk about regulations at those high level of generality, as opposed to requiring comparison at a very, particularized level. So that's the stakes of talking the language of generality in that context. Backwards on the presumption of constitutionality or not, I think that our paper is primarily addressing the coverage question on the step 1 point. And so that's before you get to the presumption. But we understand once a fundamental right is at issue, there's a presumption of unconstitutionality. We can talk about how that fits within the world of originalism. I don't have the literacy to engage with that question. But the first question is, have we even gotten so far as to say that it would be implicated if, in fact, it did fit in a theory of originalism? And where are we on, what have I not taken up here? Judd's, I think, Judd, I wanted to say that there does seem to be a problem of a trans-substantive law or way of thinking about coverage across amendments. We don't really have any law. We actually spent some time talking about this puzzle, that the justices have, this is not some major critique, but we asked ourselves if one wanted to sort of state an objection here, do they have or have they made any effort to talk about what are the characteristics that ought to govern such an undertaking? And we don't know that they have, and we're not entirely sure that they should, but there doesn't seem to be any effort to even think across bodies of law in building such a law. Should there be? That's a question.
I'll just be very brief, just two quick points, because I want to underscore something that Reva said, and I hope we haven't made unclear in our answers to questions, is that the asymmetry that we're worried about is not whether rights can trump regulation at various points. Like, we're 100% okay with that. Our question is, like, how do you know when rights and regulation have come into contact with one another? And in our view, at least, the way that Bruen does this is by giving a big, very broad definition, or the way Bruen is read, to give a huge, broad definition to the right, and to the coverage question, and then really narrowing down at, you know, we could call it levels of generality or something else, specificity, whatever it would be, what kinds of regulations would count for the government to carry its burden. So it's not a question of whether once a right, first, second, 14th, any is on the table, there should be a symmetric rights and regulation get the same. That's not our paper. I don't have a considered view on that. Now, one could.
Can I say the First Amendment does not cover all. I shouldn't. Robert is sitting here. I shouldn't say this, but First Amendment does not cover all speech utterances. It just doesn't. It's much narrower than that. I'll just say that. I'll stop.
But I would say, you know, just the last thought here, and this maybe brings us back to where we started in terms of arguments one might have to replace the tiers of scrutiny with history and tradition. Like, the primary arguments vocalized in the cases and in scholarship were we need to limit judicial discretion because there are these limits of these levels of generality problems. This calls for balancing, means end scrutiny, et cetera, right? And what we've tried to argue is that history and tradition does not outperform, thus far at least, tiers of scrutiny on that score. One could argue for Bruen and say the reason to like Bruen is it is deregulatory. It gives more power to the right and takes more gun regulations off the table. It strengthens the presumption. That is a principled argument. It's just to say we need more starch in the rule. But that's not what Bruen says out loud. Again, the arguments are we got to restrain judicial discretion. And I guess what we're trying to illustrate is, like, it may be that the real concern here was, and it certainly was among some, that the Second Amendment was being treated as a second-class right. We just need to jack up the level of protection. But that's not what the cases say out loud. And that's I guess, part of why we're concerned. It would be a much different case to just say, look, this old two-part framework underprotected the right. That's why it had to be junked. But that's not the central argument, I take, even of your piece with John or of the arguments we see in the cases.
And that's why we're raising this, we're calling this a democracy problem, because when the court does strike down the laws it's planning to strike down, it won't explain that it's making that call in those terms to the public. It will give a set of explanations that point outside and beyond itself, and in any event, that's the thesis of the paper.
And that I think actually, Tom, can I just?
Make it quick.
Make it quick, okay. So Reva, to your point earlier, I certainly understood that the article was putting forward kind of a Bruen 2, this kind of Rahimi approach as your way of addressing the level of generality problem. My criticism was, or not so much criticism, what I took you to be saying though was that choice is simply a normative choice. That it's simply a decision based on something like, I want to maximize gun rights or I want to minimize gun rights, that is the kind of choice that the justices have to make and that they're hiding. And that, which is what I thought was the claim of the paper, is what I was criticizing by saying, but there are a lot of alternatives to deciding on the level of generality that are not results-oriented or purely normative, but are instead historically grounded normative reasoning, and those are the alternatives that I and others have put forward that I don't think are addressed in the paper.
I think we leave it as a point of ambiguity in our own deliberations and in the paper often, although perhaps not sufficiently in the paper, but the extent to which the justices are, how much they understand what it is that they have a judgment not to say certain things out loud versus this is their view of what the law requires. And one of the things that's fascinating is to see the number of locations at which they're affirmatively disagreeing with each other that seem to imply a degree of self-consciousness in the crafting of doctrine around these questions. And that's an interesting question. That's not a debate about what the original understanding was. That's a question about how to craft doctrine, whether to craft doctrine and to do it in a way that will preserve discretion for them. That's the question around which you can see them deliberating and being very self-conscious. As to the other, one can assume that they read the sources in good faith.
Okay, well, we are out of time. Apologies to those on the queue to whom we did not get. I just want to say this panel, this paper, this whole discussion sort of exemplifies what's great about this conference, just sort of scholarly discussion at the highest level of sophistication, collegiality, and mutual respect, and I was glad to be a part of it.